Artificial Intelligence Law and Justice course, session 26. The topic here is Explainable AI in Law and Justice. In the last session, we discussed about Explainable AI and then the need for it. We also discussed the issues in translating that into law and policy. We highlighted different approaches to Explainable AI. In this class, we will move from a very general perspective to a very specific issue in law and justice, and then why we need XAI in law and justice. The role of explanation law is very important because judges write pages of judgments trying to tell us why they did it, what is the rationale, and more importantly, what are the binding precedents, which case laws they refer to, and what are the legal principles, and what constitutional principles. And then even if the judge dissents, that dissenting judge also has to record his or her reason in detail. So the right to appeal or the transparency and or whatever it is, people only when they are explained or only when they know why, they can say that we know why this decision has been this way. So we will be able to either appeal it or we accept it or we contest it in part or we contest it in full. So explainability is part and parcel of legal decision making, and then it is inevitable that any use of AI in law and justice has to take this into mind. But as we have seen, there are a lot of risks of automated decision-making systems. We have seen it again and again. And one of the ways the legislators and policymakers come to grips with that is that let the ADMs or automated decision-making or algorithmic decision-making or whatever the name you call it, it's a black box. That black box cannot be allowed to function as that. We need to open it up. We need to pierce the veil. So California Privacy Protection Agency has come with some draft rules where they say business should inform the logic behind the decision making, and explanation of key parameters and then application decision should be made to the consumers. On the other hand, this is not a very simple task because here we need to bridge both computer science and law. Computer science as a hardcore science technology discipline, law is a discipline that is more a social and discipline. So how do we bring them together? One way to do them together is that we need to know what are the key parameters and algorithmic explanations. But as of now, we are not very sure of that because the definition importance is not very clear. But within the whole idea of bridging law and computer science and law, you can develop a legal framework for XAI, or we can develop something to bridge that. So presenting a taxonomy for legal explanation is feasible, and we are discussing one such taxonomy in this class. And then this taxonomy can be applied for different areas in law as well as for AI systems. So the legal explainable AI taxonomy which we are discussing, it delineates the key factors with practical implementation explainable AI. So it looks into different categories, types of categories in the taxonomy. Whether the scope is local or global, which we saw in the last class, and then depth, whether it is non-contrastive or contrastive, and then what are the alternative explanations available. Then whether you want to look at the explanations as conditional or correlation. Conditional is something, if the condition X is met, if this is met, this goes. So that is conditional. Whereas correlation is that you link up certain things, with 4 or 5 factors, and then correlate the decision with that. So when you look at correlations, it is different from condition, because correlation again you can say these are closely related or these are statistically significant relationship is there. So the decision was arrived at. Then what is the scope and depth of the property we want to understand? And then the factors related to information presentation are also part of the XAI taxonomy. So the global explanation will look into the general broad model behavior or the LLM, how it functions in a broader perspective, or its broader decision making capacities, algorithm and all. This is important to understand in a larger perspective, particularly for regulatory compliance purposes. In the sense that you want to look at what the insurance system does, or what the banking system does, or what the payment system does, or what the education system does in a broader way, the global explanation is fine, very important. But when it comes to very specific instances where individuals and groups are affected, we need to go further down the line and then look where exactly the module behaves for what. In the sense that how the module reasons, takes decisions, and then is able to explain it on what basis. So to understand the individual predictions as well as decisions, this is important. For example, healthcare diagnostics, how exactly the diagnostics AI or the tool arrived at that this is cancer in the second or third stage or in the preliminary stage, or this is exactly the disease, the condition. Similarly, the same thing with criminal justice as to whether bail should be given, person should be sent on parole, or what exactly should be the sentence for such an offense. So the global will give a broader macro perspective, whereas the local will give you the micro perspective. But you need to balance both, or you need to understand both, not as contrast, but as part of the larger ecosystem. Having said that, we need to look into how do we apply this legal explainable AI taxonomy. Then what are the framework for understanding is that conditions for data subject demand explanation. First of all, the data subjects are the people who are using this, or people who are the either we can call them as stakeholders or the ones who are going to be impacted by it. So what exactly they will should know. So this should be applicable to different legal areas, different AI methods, and then the design should be abstract, but then it should be stable enough, because as AI innovation happens in a rapid speed, you should be able to meet subsequent demands and needs also. So legal prescription is something which we need to understand. For example, law may prescribe or dictate certain type of explanation for algorithmic decisions. If you take a typical credit scoring system, it should say what are the various requirements based on policy goals. For example, if I'm going to public sector bank, public sector banks are governed by the policy goals of the government. And then if I'm going to apply for a loan under this specific government scheme, then I should first know whether the bank has accepted and adopted the specific norms when it processed my application. So the legal perspective explanation is that it should be aligned with the policy goal. But if the algorithm did not take that into account and then treated mine as a general one, then I will not be able to get benefit of the specific rules under which I will benefit. So explainable AI should be able to explain to me as to why this was given or why this was not given. Then the computer scientists and the data scientists should be able to decide what exactly the suitable relevant algorithms for applying to certain explanation models. So they should tell us as to we need to map the algorithms, explainable algorithms with the overall taxonomy. Then when we do a lot of empirical research, we will know which explanation models are more accepted, which are more desired, or what the stakeholders prefer, whether they prefer one explanation model over others, and if so, for what purpose. So the software package for comparing models from field experiments, where we do a lot of field studies and then ask stakeholders' perspective, build the system with their inputs as to what they need from explainable AI. We need to look at that behavioral guidance so that when we test the system and then later we run the system, we know that this could be the explanation often sought, or this is the reasoning, and then this is the alignment with the policy goals or alignment with the overall loan processing method people will be able to relate to. So it is not mere a question of giving explanation in terms of technical details. It needs to go much more beyond that. For example, in Medicaid is the US scheme where people get access to hospitals, something like a very government system, very similar to what India you have this Anshuman Bharat, but the categorization, other things are very different. Similarly, when it goes to higher education, there could be a system, or there is a system where you can automatically apply for loan and then get, or you can automatically using your student enrollment ID, you may be able to get some benefits. So these are areas where automated decision making may also be possible. But some acts specifically mandate explanation or explanatory system as part of the overall regulation. For example, the UEAA Act seeks explanatory AI as part of its overall framework. Similarly, California, when it tried to regulate AI, the idea was to come up with a AI explainable AI as part of the regulatory mechanism, but this law got reversed in the sense that it didn't go further. So implementing the AI taxonomy in the real world is something which we need to really look into account. And taxonomy, broadly understood, is something like a structure. So we need a lot of interdisciplinary work. We need to look at the current laws and models, because the problem is that laws are meant for humans and then laws, translating those models into technical realities will be very difficult. Again, decision making models are not focusing on data subjects' interest, because data subjects' interest are not the idea of digital decision making models. The decision making models are driven more by algorithm, statistical patterns, and then statistical consistency with the overall objective of giving a decision. Whereas law does not take those algorithmic decision making thinking into practice. It treats everyone as equals, it treats everyone as the persons who are entitled for equal right and then human rights. So unless law itself very specifically says that under these circumstances bail cannot be given or loan cannot be given or this condition cannot be waived, incorporating them into the technical thing should be a factor. But then the algorithmic decision making, thinking, rule making will be very different from what the law normally says. Then there is a potential contradiction, if not conflict. So we need to really have empirical evidence as to how the algorithms work in practice, and then we need to also assess how the explanations have been really effective. So we need to do things first. We need to look at what are the effective algorithm explanations when they are put to practical use, and then what is the framework for assessing the explanation's effectiveness, in the sense that how effective is the explanation given by the algorithm. So for policymakers, both are important, and then computer scientists need to look at the intricate legal issues involved, and then how the system interprets certain rules, and whether that interpretation itself can be a direct or indirect violation of the rules. So we know the empirical evidence is a lot of things can come from it. It can result in fair and accuracy systems, and then the explanatory gaps need to be really filled into. But when we go for automation and then algorithmic decision making at all levels for all types of decisions, then it will erode the trust in institution, because people ultimately will know that it is algorithms and then machines and then some crazy computers which run the organization, not people. So the explainability gap will always be there when automation goes on, and then people not either fully comfortable with that very idea or not able to get explainable as AI being brought in to give them some convincing reasons why these decisions are made this way. So we need to bridge the explainability gap by making explainable AI part of any larger AI system, and then we should also enable benefits to the people, but it should be done without violating any legal rule or any legal law. Then the legal principles are very important. Explanation, people should be able to understand changes after adverse decisions. So whether it's a credit legislation or anything else, people should understand why the decision that was adverse was taken. Particularly, credit scoring and pricing is one of the things that is most studied in the literature, because algorithmic decision making often scores credit history of the people, scores them in terms of their eligibility or ineligibility, or eligibility with a higher interest rate, and then pricing in the sense that whether you are going to go for insurance policy or a health insurance or whatever the insurance, car insurance, those things are very important. So when you assess the credit worthiness based on algorithms, we need to also look into whether the algorithmic decision making makes it difficult for some people to buy credit or to get into some insurance premium or get into some insurance benefits on account of the higher price. Similarly, this is the example given taken from USA, but there are a lot of credit reporting agencies. There are also a couple of agencies in India also. So they share the data with bank, and then banks also process a lot of information which they also internally generate, and then these things are going to the decision making mechanism. And then there are agencies in the US and elsewhere where they look at the credit worthiness, credit history of the persons. So the credit scores ultimately can make a break in the decision making. So how do we assess that the credit scores are being used without any bias and discrimination, and whether the credit score system itself is being rightly interpreted and then applied is something which the external AI will be able to help us to understand. And then counterfactuals. Yesterday also we had a quick look at the counterfactuals. law will need that the consumer should understand all the issues, in the sense that if the counterfactual says, had it been this way or had it been this the counterfactual example I give to you, from that you can identify why you didn't get. So I can change my behavior, I can change my policy, or I can change my need, or I can go for a lower level loan and then try to get it again. So the counterfactual example should be part of the explainable AI, not to give a wrong impression that since to the consumer, but to give the consumer an idea that to understand this, look at the counterfactual perspective and then get a better view as to why this decision is reliable and justifiable. So the counterfactual examples often results in the observer or the persons who is impacted trying to get a better sense or trying to understand things more, and then they also understand which factors were more influential when the decision was making, whether his or her previous history or his or her overall credit score, or was it that his previous history was not all that satisfactory, or changes in his financial status over the last 18 months, in the sense that that person lost job, was not able to get employment for some time, so he was had lot of credit cards due spending but couldn't clear it. So the person would get an idea as to why he or she was not granted or was not given that loan. So if the factors that influence the decision making were available and known, people can change their behavior, people can be careful in future. But explainable AI should also look into very context specific applications. It should also look into what sort of audience it is trying to convince. So the legal XI taxonomy, which we are talking of, it should be able to take the policymakers and courts and then say whether which explainable AI model or method they should use. Then counterfactual we have seen, so that we can ignore now. This also we can ignore. And voluntary adoption. Voluntary adoption of this model by government agencies will help them to understand. But it is also important that some of the explainable AI models should not be algorithmic dependent, in the sense that they should not be tailored made to certain patterns of algorithms or certain algorithm. Having an explainable AI model that can be applied across algorithms is better, and such models can be called as algorithmic agnostic, in the sense that they will work with all algorithms, but then they are not crafted for any specific algorithm or any type of algorithm. So it is here data scientists and engineers, when they develop a system, particularly the one which comes with explainable AI, should be aware of these issues. Then the transparency is a major issue, because governments, when they want to go into an algorithmic decision making, they should also understand that they also should have the right to ask for transparency, and then they should also have the right to understand how the decision making process is being interpreted and implemented, and more importantly, they should also understand what they should do if the decisions are being challenged in a court of law or in a consumer forum or in some other forum. So when the government organizations, when they use, whether it is court or administrative law or education department or bank or consumer facing department, they should also know the transparency issues with third party vendors that have got significant legal implications. So government agencies, if possible, they should develop their own algorithms, or at least should have great understanding about the algorithmic decision making process, and then they should also try to rework certain things for their own benefit and then try to understand them better. So we need to do a lot of things here. First of all, the government agencies cannot take explainable AI as given. They need to do certain field level testing. They need to do certain things, like they should test across whatever the models which were given to them to test their accuracy, reliability, and then acceptability around with wide stakeholders. And then they should also look whether people are convinced with these explanations, or whether the algorithms, when they make a decision, are they able to come up with explanations that sound reasonable, legally acceptable. So they need to develop some methodology so that they can do empirical research and field experiments with these explainable AI models, algorithms and all, so that they can make them better. They also get a better understanding of how they can deal with explainable AI related queries, demands, and even notices from courts. One way to address many of these issues is that if the system, AI system, is not built on some abstract model developed for some abstract purpose, rather it is built for user-centric, aligned with the user-centric perspective, where user is not a simple piece of data or a statistical correlation, but a user is a user with a human with rights, with some expectations. Then it will be easy to bring in explainable AI as part of that. For example, the user-centric design in AI system will give importance to giving right explanations to the user. It will also take into account what sort of potential biases and discriminations can creep in when the system runs. So it would have been one that would have been already tested, or algorithms would have been tested for that. And more importantly, when we build a user-centric system, the design, it will also make that we are democratizing the technology development. We are making technology more understandable, and then users can also contribute to that. So making a user-centric design, particularly in AI development and in the context of external AI, is a good policy. But then it is not all that simple to do that, for the simple reason the systems are not meant for users prima facie. The systems are meant for the organizations that want to implement them. So when the organization that want to implement them, they may prefer technical efficiency, cost efficiency, economic efficiency over user-centric design. So this is an issue which the developers and then those who want their systems to be developed and installed have to discuss and then solve. So lots of field experiments may be needed for test robustness, applicability of the framework, and then relevance and effectiveness across legal domains. So we need to develop what I would say, yeah, not just a huge case law, but a library of all these experiments done, all the outcomes that were done with the different methodologies that were used, the different data sampling methods that were used, to give an understanding that where exactly we can make experimental AI fit well within the overall development and deployment of AI in law and justice. Now, the demand for experimental AI should naturally arise from the judicial system, but it is not happening that way, or often the judiciaries may not feel that they need experimental AI as a key component of the AI systems. It could be that they may not be able to really understand, and then they may think that this is something beyond our comprehension, we should not break our head. And the experimental AI itself may not be something that we will be able to really comprehend, it could be too technical. Then when judges confront with algorithms, they may think that I know intuitively, I know that something is wrong. But then how should I address it? How should I tell that my intuition is, how can I prove my intuition is right? So there should be a mechanism where judges can really ask for experimental AI solutions as part of the black boxes. And then they should also know how the system can explain to them the conclusions and then go in the reverse direction to tell them why step by step decision making was done, and then where exactly the decision tree finally took this decision in contrast to the other decision. So the role of courts here is very important. They can play a huge role in developing effective explainable AI, provided judges are also keenly interested, and provided judges work with the developers and the deployers. And more importantly, judges are also empowered to deal with them effectively, instead of making judges as mere lame users of the systems. So this again, as we said yesterday, is part of the public involvement, and then it also enhances judicial involvement. But in some other legal contexts, like deployment of autonomous weapons, which is again a huge controversial area, right now there is no global convention, but then informal talks, or what you would call as not exactly among diplomats, track two diplomacy efforts are going among various stakeholders in that. But more importantly, experimental AI will be required in a field called health, where doctors can be sued. We will see that in another session. Or doctors may have doubts about the diagnostics or the classification or the treatment prescribed. So the legal consequences for them is one part, but even for their own better understanding and for their own professional requirement, including the ethical requirement, doctors should also see that explainable AI systems are available to them. Then we have a huge upcoming literature, developing literature on algorithmic decision making, and then which decisions really need explanation, and then which form of explanation they should take, and then how the algorithmic decision making uh, and then explainable AI should be co-developed. So as we said, judges have a lot of roles in that, and more importantly, judges should also look into what sort of external models are preferable for the work they do. So if there are multiple forms of currently available where explainable models are available, and they're being increasingly developed. So some models which are intrinsically or have the inbuilt capacity to be externally AI, then they may be used, but then some studies show that they are less effective in the sense that they are not technically very efficient. So the interestingly external models, although they seem to be prima facie preferable, it is not should not be at the cost of technical efficiency. So we discussed about global interpretability and then what exactly the intention behind the developer when he or she developed it, and then what are the parameters, and then what is the qualitative input data that was fed into, and then how does the system deal when it is fed with new data which it has to process or it has to use for learning and decision making purposes. These are some of the things where we need to look into when we build and then when we look at explainable AI itself being developed. So auditing outcomes could be one way, and then attempting to explain the whole system or whole model in terms of a explainable AI explainable type of explanation is another way to look at it. So as we said, courts have a huge role, and then when judges ask for meaningful explanation, judges should also know what sort of explanations will be available, and then what sort of thing they should primarily focus on. Should they focus on the core explanations that really matter, or should they go for a detailed explanation that describes each and every step? So there is a whole lot of challenges and opportunities for explainable AI in government agencies, government departments, including courts. But there is a lack of what one would say clarity and confidence when it comes to explainable AI for three reasons. One, the subject itself is very new in the sense that it has not been widely deployed across AI applications in all sectors. In law and justice, the application of AI models itself is relatively less when it compared to some other sectors. So, what exactly explainable AI here means is something that not many people understand, or even if they understand, they themselves are not very clear. Then, the third and most important point is that there are a lot of things which are vague or unclear at the moment when it comes to applying AI in law and justice because the AI governance or the AI regulation itself is not in place in full in many countries. So many countries are adopting a piecemeal approach or sectoral approach or innovation focused approach towards AI regulation. So when that happens, it is possible that those in judicial decision making or those who are in the law and justice system may think that the regulation itself is not geared toward that. So when the regulation moves towards direction, it could be the right time to go for external BAI because right now our concern is not just on external AI, but we have other broader concerns, including whether the systems are really compatible with AI and rule of law, and then what sort of discrimination biases actually happening when the systems are deployed. So external AI is part of a solution, but then there are a lot of other things which need to be addressed before we come to this part of the solution. So this is the case where State versus Loomis. The algorithmic trained by the computer scientists have were biased. So he compresses a system used in an algorithm. So he categorized the defendant as a high risk recidivism. Recidivism is that the potential to indulge or commit crime again. So here the what happened, he was not given bail. So the recidivism is said, I am protecting recidivism, so I am not able to give him the bail. So he challenged that. First, he said Use of compass itself violated due process rights, but then this was not accepted by the court. But then he could not access the compass accuracy was a key concern for him. So ultimately, what happened in this case, while his concern was not addressed fully, it exposed thoroughly that the system was biased. So the need to move towards transparent algorithms as part of explainable AI is very obvious here. And then courts should demand explainable AI, particularly in critical applications in criminal sentencing. So there could be different ways of doing explainable AI in criminal justice. In the sense that in administrative law, it is the executive agencies, judges, corporate interest stakeholders. So these actors know well, in the sense that they are well equipped, they are powerful enough, they are resourceful enough. So they may not hold a lot of capacity building or hand holding in it. Whereas in the criminal justice, often criminal justice interferes or interface has interface with the downtrodden, with the poor, who often end up as victims or who often get unduly punished proportionately speaking to the crimes they committed. So here the stakeholders on the other side, or the persons who are facing the judiciary and the law, should be empowered through explainable AI models, and then they should be the ones who should be really able to challenge. Whereas the judges first should understand before trying to justify the decision as to why this decision was given by the system. And then it is the duty of the state to ensure that explainable AI becomes part of the criminal justice system when AI systems are being deployed. So this again we saw we need to look into very specific examples where before being deployed, judges have an understanding, have done some field testing or have done some random testing with that, and are convinced that the system is able to give reasonable judgments, or at least the decision making is something which they see the potential to go wrong as much less. So using explainable AI in criminal justice is not only necessary and but also should be the essential component of using AI in criminal justice. But often the systems are black boxes in one sense, in other sense, they are covered by IP rights, they are covered by proprietary knowledge, and then how the system works is very difficult even to understand. So the companies or the developers will not be willing to disclose the algorithms that are being used. And then they can also use the trade secret as one of the IP rights, we know that. And then they may build they may be asked to build surrogate models like synthetic data. We can have surrogate models which are not identical but are very similar or have the similar reasoning algorithm built in, so that this trade secret issue can be partially overcome, and then we can say fine, we will use your surrogate model, run it on this data, run it on this algorithm, and then see, you explain to us as to how this decision making was done. So this is a partial solution to address some of the things related to trade secret over algorithms and then algorithmic decision making. In a case like Loomis, had such a type being done, it would be easier for the Loomis to decipher and then contest and then challenge, rather than the system becoming too opaque, or when the due process using of the AI in the due process itself as part of the solution was not held as a violation of due process. So we need to look at from the perspective of stakeholders who are in the receiving end. We need to see how algorithmic decision making can be challenged through explainable AI, even if there are certain constraints like proprietary algorithms or trade secrets or any other IP rights that constrain building such explainable AI systems. So this and all we know, but courts are not often very demanding or very forthright in asking for explainable AI, because, as we said, that it is totally new, and then trade secret hurdle, and then algorithms are very difficult to understand, and then courts often may not have the full confidence in using AI itself, in the sense that even if the AI system is used, they may not be the ones who don't have 100% confidence. So they may not think in terms of or asking for explainable AI, because they know that if they go and ask for explainable AI, that solution will come. But then it would also amount that they are fully convinced about use of AI in court law and justice, particularly in court decision making. So making explainable AI part of the real world core systems, trying to refine it for better. And then when we use more and more of explainable AI as part of the criminal justice and administrative law, there's good scope for everyone, including lawyers, academics, developers, software developers, people who develop specific systems for legal applications to learn more, understand more, and then increase the transparency of the AI systems. So there are a lot of other broader legal contexts like product liability, then malpractices in medicine, then government decisions. Sometimes government freezes an account or government says on account of this violation, we are taking over property or your access to your property is limited. So with that decision is being made on account of algorithm, explainable AI should be part of that. So basically, explainable AI should be available to the defendants as part of their legal right. But translating this into practice is very difficult because right now defendants don't have the right. They have the right to appeal, they have the right to question. But only when algorithmic decision making is very widely used and then bringing algorithmic decision making as part of the solution, then explainable AI as part of the one of the tools available to defendants, it will make sense. On the other hand, when the defendants do not even know that it was the algorithms that had a major role or it was the algorithms that ultimately decided, they will have no recourse even to ask for explainable AI. So prior to thinking in terms of explainable AI in court and justice, we should also look at the transparency level of the judicial decision making when it comes to using of algorithmic decision making in judicial decision making. So we need to go beyond this, and then the next class we will look at AI and labor law. Thank you.